Welcome to Looking at Legal Stuff. Today we have 7 hearings in a case with a couple where dad is motioning the court for primary custody, claiming mom is encouraging their son to stay primarily with her despite their 50-50 parenting plan, undermining dad during his custody time, and discussing the court case with their son. He claims they split up 2.5 years ago when mom lost her job as a correctional officer after she had an illicit affair with an inmate, and now they live together and have a toddler. Dad claims their household is not a healthy environment for his children, and he's concerned about drug use, DV incidents, and inappropriate behavior by this boyfriend and his daughter. Mom claims everything Dad says is exaggerated or a lie, and she can't understand why the court can't see that. She attempts to refute Dad's claims, but he has a very competent lawyer, while she's filing as pro se and doesn't have a clue how any of this works, leading to her constantly getting frustrated and upset. Will Mom stand a chance at proving Dad wrong? Or will this end in yet another meltdown? Let's watch.
Going to the final matter, 24-3-00026-08, Swindell v. Sindana. I'm guessing at the name, apologize. All right, so first off, I see we have Ms. McLean,
Yes,
and looks like we have Ms. Is it Swindell? You're muted.
Yeah, it's Swindell.
Okay. All right. So, Ms. Swindell, the problem is that when I was looking at your documents, they're not sworn affidavits. And for me to consider them at all, they need to be sworn declarations, and they're not.
Okay.
So you understand that?
Yeah, I
So,
do. Is there a way I can make them sworn affidavits?
well, it's always difficult, like I have said many times, is I understand you're not an attorney, I understand you may not understand the rules, but you're held to the same standard of the rules. So let me hear from Ms. McLean in regard to that idea. Ms. McLean?
So my concern is that obviously we had Ms. Swindell appropriately served for this motion. Her responses were late regardless, and she didn't technically serve my office. She apparently had a copy delivered to my client, and I had been watching on Odyssey and observed that the documents had hit Odyssey. So that's how we became aware. Nonetheless, we've been able to put together reply documentation for my client. And given the concerns, we do believe it's appropriate to move forward.
All right. Well, I am going to move forward today because there are significant issues and concerns. But you need to understand one thing, Ms. Swindell. First off, anything you file with the court, you must serve on Ms. McLean's office, meaning you provide a copy of it to Ms. McLean's office, okay? So that's one thing. Secondly, local rules have the timing of when motions are filed, the timing of when things are due. And if you don't do that, then the court likely isn't going to consider those documents. So even if you had sworn affidavits, then in regard to that idea, that they weren't timely. So you had two things in regard to those issues. Finally, I want you to understand this is a temporary order idea. This is not a final decision on anything. So I want you to understand that as well. Okay. All right. So Ms. McLean, with that, go ahead.
Thank you very much, Your Honor. So may it please the court, I do represent the respondent, Tucker Sandana, And just to make sure that the record is clear, this is cause number 24300002608. The court has already addressed the initial concerns as it related to the unsworn declarations. And I can tell the court when I was reviewing through Ms. Swindell's reply documentation, there are a number of text messages. I had difficulty understanding a time frame for many of those as they were not referenced in her declaration. The text, most of the texts themselves do not provide an actual date as to when these communications occurred. And at times it was difficult for me to understand who the communications were between. So I would just point that out and suggest that the court provide minimal to no weight as it relates to those text messages.
So I'm going to
These-
stop you for just a minute, Ms. McLean, on that. This is another thing I wanted to clarify, and I should have done it earlier. One, when people send in massive amounts of text messages, chances are we don't have time to even review all those text messages. And I don't remember how many pages there were of that, but 88 pages, I believe is what I have. We don't have time. But the other thing is that people often don't, one, give us dates. So I have no time frame. I have no time, no date, or who is even saying what. You may know when you copy it who's saying what, but I can't look at them and just go and know. So I want you to understand that as well. Okay, if you don't give any context to what's being talked about, there's nothing I can even figure out from it. So, and when I looked at the text messages, that was pretty much what I saw. Okay. All right, Ms. McLean.
Thank you very much, Shonner. So these folks have an 11-year marriage and they separated about 2.5 years ago. They do have 3 children born as issue of their marriage. Jada is 11, Raiden is 13, and Jackson is 15. And as you can see from the documentation submitted by my client, these parties originally had filed for dissolution in Clark County. They were both residing in Clark County at that time. At that time, they had agreed to essentially a joint custody parenting plan with the children exchanging between each home on a week-on, week-off basis. Ultimately, that action in Clark County was dismissed for want of prosecution, and both parties have subsequently relocated to Cowlitz County. Most recently, Ms. Swindell has been influencing Jackson and encouraging him to stay with her primarily, even though the original parenting plan provided for a week on, week off provision. But as my client outlines in his declarations and documentation, there are significant concerns within the environment from Ms. Swindell. Jackson, obviously, at 15 is a teenager, and he is going to go to the location of least resistance, or at least in this case, the area of least rules. Unfortunately, Ms. Swindell has been involving Jackson in the litigation, encouraging him to stay. And even if you did have a chance to review some of the text messages, you'll see that there have been times when she has communicated with him while he's been at his dad's house and undermined Mr. Sandana's parenting authority during his residential time. On the other hand, Ms. Swindell also is of the opinion that if the kids are getting what she perceives as passable grades, then they're allowed to skip school, which is unacceptable to my client. And she has gone so far as to encourage Jackson to quit school, obtain his GED, and has discussed smoking marijuana with him. All of these things are concerns relative to her behavior, as well as her historical presentation. Clearly, Ms. Swindell has significant questionable judgment. We see that within her parenting of the children. We see that within her own current relationship, and we see that within factors that resulted in her losing her employment as a corrections officer. As my client tells you, and you see some of this in Ms. Swindell's responsive documentation, the parties were in a fairly drawn out hearing relative to ongoing harassment by Ms. Swindell and her significant other directed towards my client and his significant other. The concern is that Ms. Swindell is currently involved in a relationship with her former inmate with whom she had an inappropriate relationship with. They do have a child together. He also has a child from a prior relationship who has been engaging in inappropriately sexually charged behavior in front of or when the children are present at their home. And this is a matter that is currently being investigated by CPS, from what I understand. My client has put in the request for CPS records, but as the court knows, that takes ages to get for a private citizen. And we're hopeful that a guardian ad litem would be able to cut some red tape as far as securing those records earlier. Ms. Swindell's significant other has a very violent history. He resides in the home. And as my client has told you, there have been instances where essentially he's been acting as the heavy on Ms. Swindell's behalf in order to force compliance by my client to her whims. My client tells you in response to Ms. Swindell's bald assertion that my client has been abusive, that in fact my client has been the victim. Ms. Swindell failed a Washington State Patrol onboarding employment polygraph because she was unable to answer that she had not been involved in domestic violence. My client tells you about her circumstances where she had pulled his hair, she had beat him, tells you about an incident early on in their marriage where she pulled a knife on him, also provides a police report from 2021 where she had threatened to kill him. Couple that with her own history of mental instability, and she acknowledges that she is not currently apparently on any prescribed medication. She's not currently in treatment with any type of a counselor. She identifies in her declaration that she utilizes marijuana to control her PTSD. The concerns are that marijuana is not appropriate for individuals with PTSD. It also can counteract her depression, which clearly has led previously to suicide attempts for her and hospitalizations. There's no way to meaningfully identify how much marijuana she's using to appropriately address PTSD. And again, that's contrary to medical recommendations. So at this juncture, we are very concerned by the environment within Ms. Swindell's household. Again, allowing the children to miss school, negatively impacting their performance. Ms. Swindell openly denigrates my client during text messages that involve the children, where she's calling him denigrating names. And as referring to my client's girlfriend in inappropriate terms. Unfortunately, even the children's medical issues have turned into a battlefield for Ms. Swindell, where she will cancel appointments and reschedule during her time. She will exert herself in an attempt to promote a false diagnosis or narratives. Even the sealed health documentation that she provides, which is from a well child check for Jackson in November of 2023, which I think is the child and adolescent clinic, although it's not on letterhead, but I believe the location CAC Longview refers to child and adolescent clinic, where even Jackson acknowledges mom is forcing him into counseling. We have none of the counseling records for the children, but clearly there are concerns as it relates to the children's environment with Ms. Swindell. We are asking that the court place all three children primarily with my client. We believe it's appropriate for there to be limited visitation. We're proposing first, third, and fifth Saturdays from 12 noon to 6 p.m. There should be a prohibition about Mr. Musso or his daughter being present during those visits. We're asking the court to restrain Ms. Swindell from using alcohol, legal or illegal substances unless prescribed by a physician, and that my client be allowed to ask for UAs, hair follicles, and the like standard provisions that are outlined in our proposed parenting plan with the loser paying. We are also asking the court to order Ms. Swindell to undergo a collateralized substance abuse evaluation and parental psychological evaluation with parental risk components. Obviously, it is concerning when an individual is somewhat excited about the opportunity to smoke marijuana with their children and is almost giddy about explaining that she was involved in a drug deal. Given her history, that's very concerning as far as what's going on within her household and her outlook as a parent. So we're asking the court to adopt the parenting plan that we've proposed. We do believe that it's appropriate for a guardian ad litem to be appointed in this matter. Given the relationship difficulties between the parties, my client is also asking for the entry of a restraining order. The proposed parenting plan provides for the exchange of the children at the Kelso Police Department, but we are asking for a restraining order that my client, that Ms. Swindell not come to my client's home, workplace, school, etc., that she not disturb his peace and that she not threaten any type of assault or domestic violence. We believe that that's appropriate given the current status of this case. As it relates to financials, my client is employed as a supply planner with Ecolab. We have provided under seal documentation relative to his current wages and last year's wages. We're asking the court to set his net income at $5,785 per month. Ms. Swindell has not been forthcoming with regard to her income or assets. As we've indicated, Ms. Swindell has a family trust that apparently provides monies to her, as well as provides or has paid for her existing housing, which we understand she owns free and clear. She has a history of employment as a corrections officer, and it's our position that income should be imputed to her. For purposes of the child support calculations that have been submitted to the court, I've used the national median income for an individual her age, because as I sit here, I have no clue what her historical earnings have been. But obviously, as a corrections officer, that would have been significant. The basic child support calculation for the 3 children would be $951.90. We do recognize that Ms. Swindell has another child with Mr. Musso, so a deviated child support amount would provide for $796.86 per month. We're asking that the court adopt that effective March 1 of 24, and that Ms. Swindell pay her proportionate share of uninsured healthcare expenses and extracurricular activity expenses for the children. Finally, we are asking the court to allow my client to claim all 3 children as dependents on his 2023 tax return, as Ms. Swindell apparently does not currently have any taxable income. We believe it's appropriate for my client to claim all 3 children. Thank you.
Ms. McLean, you said from her declaration, what declaration are you referencing?
I'm referencing, so she did provide a cover page, and I just looked at the first and considered the first 3 pages of her declaration.
Okay.
So if you take a look at, for example,
right, and I apologize, Ms. Swindell,
okay.
it would be admissible.
I'm sorry, what?
So I want to clarify on what you filed with the court. The part that would be admissible that was talked about are the first 3 pages of the 88 pages that you filed. That's your letter. So anything that's in that you can talk about. Do you know what I'm talking about?
Yeah, sorry, I'm just trying to get my bearings. I so first I want to talk about how inaccurate Mr. Sandana's document was then. He lied about multiple dates on his document. We did not get married in 2010. We got married in 2009 when I was 17. We also didn't separate in 2001. And I know I can't talk about it, but there's a police report. If we can extend this, I can get it sealed and put it in, of us even fighting in 2000, before the date even says sorry, I'm so flustered. He lies about when we separated. Also, I did not get fired from DOC. I quit. And yes, it wasn't necessarily to pursue a relationship, but I knew that my time in DOC had ended. The way that Larch Correction Center was ran, I did not agree with, so I quit. And yeah, I did meet somebody there, and we are together in a very healthy relationship. There has been nothing negative that's come from this relationship. I would also like to point out that Mr. Sandana says that Mr. Musa was used as a heavy. Mr. Sandana had no problem leaving our children with Mr. Musa while I was in the hospital for 11 days for visitations. They had no problems correlating that. He would leave our kids with me every morning on his visitations and every evening.
Lauren, some of this is outside of the scope of the declaration.
It's just the 3.
Am I allowed to talk about his declaration?
Only if you responded in your declaration.
Okay.
I mean, if you agree with what he's saying, that's one thing. But if you're disputing it and you didn't dispute it in your declaration, then no.
Okay.
That makes sense.
I'm sorry, I'm trying to remember everything that was a lot in there. That was what was just in the first 3 pages, but there's been an escalation of behavior. It seems like every time if I play by the rules for Mr. Sandana, everything goes fine. We can co-parent just fine. And then as soon as my son doesn't want to get his hair cut and Mr. Sandana is forcing that on him, and I step in for my son and he's pushing these rules, and that's what I talk about in my declaration is an escalation in behavior this happening. And now that I've filed this with my son, my 15-year-old son, our 15-year-old son, asking to live primarily with me,
I guess I would object as to the hearsay.
I mean, there's a lot of hearsay
I
in
can
his
figure
too.
it out. Just go ahead.
Okay.
I've never done any sort of drugs in my life. I am in active therapy. I see 2 different doctors. I just had a near-death experience last year, and so I'm definitely still healing from that. I'm actively in therapy. I encourage my children to be actively in therapy. I don't go into their therapy sessions. My oldest, he's 15, they just butt heads. I'm not trying to like start this drama, but I do feel like when it comes to my kids, I do explode, and I'm trying not to, but when he's not letting me talk to my kid and I haven't talked to him for, but there's never been any sort of like, there was when we first separated, there was the big, explosion. Then he started dating, I was dating, we were good for like, and then now that things just aren't going his way, now he wants to, he's had people come to my house multiple times to sign, and that's in my declaration too, to come sign divorce papers multiple times. Nothing's been filed. Like, he has the money to do it. I don't have a trust fund that pays for my stuff. There is a trust fund, but we don't get anything from it because the park doesn't have any revenue. So if it sells, then yeah, I'll get some, but we don't have any revenue coming from that park. I haven't since like 2016. So I can provide proof of that. Like, I just need time. I don't know how to get all this stuff. I'm not an attorney. I'm sorry. And I feel like this is legal abuse. This is parental alienation because he's calling my kids into the room, talking to them about how dangerous I am, who all these dangerous people I hang out with. I'm building a business with my best friend since middle school. I smoke a little weed and that's it. And it's not even, CPS has come in because he's contacted CPS. He's had people contact CPS. They've come in, it's closed. I also provided that, but it's not, I can't talk about it.
Anything else?
I guess that's all I have to say.
Ms. McLean?
I don't think I have anything further.
So this is always difficult when one party is represented and the other is not. I understand your frustration, and quite honestly, the court gets frustrated with not knowing necessarily the full picture. I'm not saying that against the father. It's just one thing that I would note. And as I said, the same rules apply whether you're an attorney or not. The one thing there are organizations that you can make contact with, and so that's all I can say in regard to that.
I'm on a waiting list for one.
Okay. So, as I said, we are going to move forward. And so based on the admissible files and record, the court does order the following request of the father at this time. In regard to the proposed parenting plan. Let me go through that. I will adopt the 191 factors on paragraph A. On paragraph B, I will reserve. In regard to the limitations, visitation, at least at this time, will be the first, third, and fifth Saturday of each month from 12 noon to 6 p.m. Subject to the following. The father may request random observe urinalysis, hair follicle, or nail tests of the mother at any time. The father shall prepay for the testing. All testing shall be observed by the testing agency. If the mother fails to provide the requested analysis testing within 4 hours of request, said failure shall be considered a positive test, and all visitation shall be suspended pending further court order. If the mother submits to testing and said testing shows positive for illegal or non-prescribed drugs, including marijuana or alcohol, or as validity concerns, the mother's visitation shall be immediately suspended pending further court order. Failure to submit to testing a positive test result for drugs or alcohol as outlined above, or test results where validity is questioned, shall require the mother to reimburse the testing costs to the requesting parent within 7 days of the testing date. If the analysis testing is negative, the requesting party shall bear the cost of the testing. Copies of all the urinalysis testing results shall be provided to both the requesting parent and the parent tested. The mother shall be enjoined or restrained from talking negatively or allowing third parties to talk negatively about the father to the children. The mother shall provide their current address and phone number at all times prior to their visitation. The mother shall be enjoined or restrained from being under the influence or consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider. The mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and or Kiana Musso or any known domestic abuser, drug user, any individual under the influence of alcohol or drugs. In regard to evaluations, the mother must be evaluated for and receive the following substance abuse evaluation. I am not going to order the psychological evaluation with parental risk components at this time. That will be reserved. The evaluation shall consider input from the other parent and the guardian ad litem. Evaluation shall be completed with providers agreed upon between the parties and are approved by the court. All evaluations and participation in any recommended treatment shall be at Ashley Swindell's expense. The mother shall start or continue and comply with treatment as recommended by the evaluation. The mother shall provide a copy of the evaluation and compliance reports to the other parent and the guardian ad litem within 5 days of receipt of the same and to the court and all parties under seal. If this parent does not follow the evaluation or treatment requirements above, then 1, failure of the mother to provide evaluations as recommended by the guardian ad litem shall be cause for the father to have visitation issues and to the mother reviewed by the court. The court shall maintain jurisdiction to ensure compliance and or enforcement of this provision. As to decision-making at this time, it will lie with the father. And they are listed out in the parenting plan. I'm not going to read through everything. Dispute resolution shall be by the court. Excuse me. In regard to parenting time, I've already talked about that. Transportation, the children will be exchanged for parenting time at Kelso Police Department parking lot. Each parent should pick up and or deliver the children to the exchange location identified above, being the Kelso Police Department. The children shall transport themselves from each parent's vehicle to the other parent's vehicle. So in other words, I do not want disputes and fights and arguments at the Kelso Police Department parking lot. The children shall be picked up and returned at the designated times. Should a delay become necessary, the other parent shall be notified immediately. All transporters shall be timely in their transportation exchanges of the minor children to avoid delay of more than 15 minutes following the time of exchange. If there is an emergency, that information shall be relayed as reasonably as possible to the other parent. If the parents transport the children by automobile, then age-appropriate children's safety restraints shall be used at all times during said transportation. B, only licensed and insured drivers may transport the minor children. Failure of the parent transporting the children to provide proof of insurance shall result in a waiver of visitation until such time as appropriate documentary proof is provided. I'm not going to go through the moving with children. That's all in there. If either party moves, what that takes. And then paragraph 14, it just talks about education, information regarding the children, the exchange of that information, the communication with children. And I want both parents to make sure to read that and follow it. So with that, I'm signing off on the parenting plan. So Ms. Swindell, in regard to the parenting plan, I know you don't agree with it. I just need to know if you approve via Zoom.
I'm sorry, what?
So your your signature is not on the parenting plan. And I know the signature does not mean that you approve of it necessarily. It's just whether or not I can put approve via Zoom because it's what I'm ordering.
So I have to say I approve it?
It's up to you.
No, I don't approve it.
Okay. All right, in regard to the in regard to the restraining order. I am signing off on that restraining order. Ms. McLean, will you be getting copies of these things to Ms. Swindell?
Yes, I will, Your Honor. Would you please, on page, excuse me, page 2, paragraph 4.
I
Mark
marked it.
Okay, and then also on page 3, paragraph 7, ask that the court indicate not required since we already previously served it and it's similar. That I will provide conformed copies of all documents to Ms. Swindell.
So Ms. Swindell, in regard to this, I have to ask you the same thing. Do you approve via Zoom? It doesn't mean you agree with it. It's just that it conforms to what I'm ordering. You're muted. I don't know if you know that.
Yeah, that's fine.
So I'm just putting approved via Zoom. Again, that's not to say that you agree with it. It's just that it reflects what I'm ordering. Understanding that, Ms. Swindell, do you want me to change what I put on the other one?
Yeah, please.
Okay. All right, and then in regard to child support, the court is adopting the child support worksheets, imputing at the median income based on the work history with the commencement of March 1.
Your Honor, I haven't worked since December of last year. I was hospitalized and I've been at home taking care of my kids since then. I don't know what you want me to pay child support with.
Basically, I'm finding that you're voluntarily unemployed and that you have the ability to be working full-time. I have nothing to show me any differently. So it starts, I'm going to make as April 1, not March 1. So it doesn't go back in time if that's what you're thinking.
So did the court make that change at paragraph 11?
I will, but in regard to the child support worksheets, are you, okay to again, understanding what I'm ordering, not that you're approving it, to put approved via Zoom?
Yeah.
And then I'm going to appoint a guardian ad litem. Who do we have next on the list?
That is Sherry Evald, Beth Bellows, Karen Lawrence.
Ms. McLean, do you strike any of those?
I don't think I have any objections.
So, Ms. Swindell, basically you have a right to object to any three of these if you so choose. I know you're probably not familiar with them, but it's up to you.
Yeah, it doesn't matter to me.
Okay, so we go with the next one on the list, which is Sherry, is it Evil?
Evald.
And is it SH?
SHERI.
And E?
VALD.
So this one, I'm actually going to need a different order. Ms. McLean, under the application from Ms. Swindell, it states that she's indigent. That was upon filing of this matter. And so that would mean I need to make her half payable by the county.
Is the court willing to just interlineate that on the top of page 4 under petitioner, that would be county pay? Her 50% would be county pay.
Problem is that the amounts are different.
Oh, okay. So, so how do we handle that? Do we, which threshold do we use then? Let me go back to, I don't remember off the top of my head what the new amount is for county. So, excuse me,
So the private
it's
pay would still be
1485.
correct.
So, okay, so
What I've
the
seen is
50%,
that the 3,300 is for the one paying
right?
private pay, and the 1,485 is half of that is what's
So
for
why don't you do 1650 instead of 15% for the respondent, and then 742.50 would be for the petitioner, $742.50, and then maybe just reference that that's county pay. And then,
Hold on. And Ms. Swindell, I'll explain this here in a minute. And what did you say the amount for the respondent?
1650. So the 3,300 total then would be changed to $2,392.50.
So Ms. Swindell, are you there?
Yeah.
So in regard to the guardian ad litem, I determined based on the indigency for the filing that your half would be paid by the county. And the respondent's half would be paid by him. So that's what those figures are all about.
Okay.
And they go
And
at
then-
different rates, county paid versus private pay, and that's why the two different figures are being talked about.
Okay.
Okay, all right.
And then does the court want to add a reservation language for review of reimbursement once we get
I
further
am.
discovery?
All right, I did put review of county paying petitioner's half is reserved for further review once income is known.
Okay.
All right, so Ms. Swindell, again, are you okay to put approved via Zoom on this?
Yeah.
And could I inquire if Ms. Swindell has an email that she can share for that form as well for the GAL to reach out to her?
At gmail.com.
Thank
So
you.
Ms. Swindell, on our Cowlitz County Superior Court website, there's a page for the guardian ad litems. And go to that page and you can look for Sherry Eval's name and contact information. And you can let her know that she was appointed as the guardian ad litem in your domestic case. Okay, do you know what a guardian ad litem is?
No, I don't.
Okay, guardian ad litem is somebody appointed by the court to investigate the best interest of the children and make a recommendation to the court as to what they see, as I said, the best interest of the children for visitation and schedule and that kind of thing.
Okay. I understand to a certain point, but how are they gonna know if they don't ever see the children in my care? Or will they?
Well, work that out with the guardian ad litem,
Okay.
okay?
All right.
So they're trained, they know what they need to do, they know what they need to ask you for.
Okay.
Okay, all right. All right, so I have signed off on that order.
And then you should have a temporary order.
Okay, and then the email, I'll just put in here, Ashley. Swindell. You said it was 91
Yes.
and it was at what?
Gmail.
Okay. All right, so I've signed off on that. That brings me to the temporary order, and all the temporary order really does is, there are some additional orders that I did not talk about. the petitioner will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to a 2020 Chrysler 300 and 2005 Dodge Durango. And then the respondent will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to the 2018 Ram Rebel 1500 and 2021 Yamaha R7. Both parties must not move, take, hide, damage, borrow, against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic needs. Both spouses must notify the other about any expenses that are out of the ordinary. The petitioner and respondent must each be responsible for their own future debts, including debt from credit cards, loans, security, interest, and mortgages, unless ordered differently. And then the respondent at this point, Tucker Sindana, shall be allowed to claim Jadis Sindana, Raiden Sindana, Dana, and Jackson Sindana as exemptions and or tax credits for the tax year 2023. The petitioner, Ashley Swindell, shall complete, sign, and mail to Tucker Sindana IRS Form 8332, release or revocation of release of claim to exemption for child by custodial parent for the tax year 2023 as to all 3 children. Ashley Swindell shall mail the completed IRS Form 8332 to Tucker Sindana within 14 days from entry of this order with the court. Okay, that form, I believe, can be found online. I'm not quite sure. But that form you do need to get signed off and mailed to him.
And if Ms. Swindell has no objection, I can also email that to her, and we can arrange for her to electronically sign it if she would prefer.
Yeah, that's fine.
Okay, we'll get that done.
Thanks.
Are you okay if we email you conformed copies of the orders, or do you want me to mail them to you?
Email's fine.
Okay, all right, thank you very much.
All right, and I'll just approve via Zoom. Are you okay with that?
Yeah, that's fine.
And just for the clerk's edification, the GAL appointment order sets a 30-day compliance on the GAL process of April 30th at 9 a.m.
You know,
And then,
that's fine, I guess. That's spring conference.
oh, I didn't know that.
I don't know what dockets they're gonna have.
So could we set that then to May 7?
That would be fine. Let me get that back. Ms. Swindell, what I'm talking about is the judges go to a training for a few days, and so we don't have our regular dockets. So I'm going to change the date of April 30th to May 7th. So Ms. Swindell, your next court date is going to be May 7
Okay.
at 9 a.m.
And then that also sets a final GAL review on August 6th at 9 a.m.
Okay. All right, so those are 2 important dates to remember. But Ms. McLean will get you a copy of everything. So make sure to review it and read it carefully. Again, understand these are temporary orders. These are not final orders. And make sure to make contact with the guardian ad litem.
Yes, ma'am. Do you know when our next court hearing, will there be a chance for this to be changed, the parenting plan?
I will look at the report if the report is done and possibly consider it. Just depends on what the content is.
Okay, and then also I know it said something about a UA and there being no marijuana in it. I have smoked marijuana, so it's gonna be in there if I go to like take it today or in the next 30, 45 days.
Yeah, that's understood.
Okay. So they're not going to just like not let me see my kids if it's in there a little bit, right?
Ms. McLean?
What's your last day of use?
Today.
Okay.
Fine.
All right. Yeah, I'll discuss that with my client. We'll take that into consideration. Obviously, that's on the record as well.
Yeah. Okay.
All right.
Okay, thank you.
Thank you. That takes care of everything for today.
All right, Swindell and Sindana, 2430002608.
Yes, Your Honor. Noel McLean appearing on behalf of the respondent, Tucker Sandana.
All right, and it looks like, and we have Ashley Swindell present.
Yeah, I'm present, Your
All
Honor.
right, thank you very much. You just, every once in a while I review my notes and they don't make sense to me, and so I just have to look at something before, and then it all usually comes back. So just give me 1 second. So it looks like there is a motion. The contempt motion isn't on today. Today is the motion for temporary family law order, correct?
Yes.
And that was filed by Ms. Swindell, and it looks like there is a new proposed parenting plan being requested for those 3 children. And right, and I reviewed, for the record, I've reviewed that motion, the declaration and support, the proposed parenting plan, and then the reply declaration. And let me just, the reply declaration. I'm weeding through here to make sure that I'm not conflating the contempt motions with or contempt responses with the responses to the parenting plan. So Ms. Swindell, go ahead. It is your motion.
Thank you, Your Honor. First, I wanted to emphasize to the court that I have been the primary parent for all of the children up until March 19th, the last court date. And that Mr. Sandana had no issues with our children being around me, my partner, or my partner's child until I filed for full custody of Jackson, which would have required him to pay child support. The sudden shift in this stance shows his intentions are financially motivated rather than focused on the children's well-being. Despite having the ability for years, Mr. Sandana has never put our children on medical insurance. They have only had state medical coverage or the medical insurance provided by me through my
Your Honor,
work.
I guess I'm going to object at this point, as this exceeds the documentation that I received. And I note at the top of this motion, Your Honor indicated you reviewed a declaration. I've not received a declaration for this motion. I received a motion for temporary orders, an information regarding a temporary parenting plan, a proposed parenting plan. And then subsequently, we had received a proposed temporary family law order, child support worksheets, child support order, and the docket notice and a summons to modify the child support.
Okay, I didn't receive any of the child support information, so I don't have that, and I don't see that as part of her initial motion. So I don't have any of that before me, so child support is not something that will be discussed today. And I will clarify, in Odyssey, it is listed as index 53. It says declaration in support of a parenting plan. When you look at that, that's the information for a temporary parenting plan. So I don't know if that was entered incorrectly or because it's not a declaration. As we think of declaration, it is the information for a temporary parenting plan.
Right. So given that, I would object to the argument that exceeds the scope of her declaration.
And I'll sustain that. So Ms. Swindell, you need to keep your argument to the information that's been provided to the court and the other party.
Yes, Your Honor. Yes, Your Honor. Okay. So our oldest son has been grounded for over 2 months, which I believe I've put in the letter that I've given to the court and to Miss Noel. He's been grounded for communicating with me about issues that are going on in the house. My middle son,
Yeah, I'm sorry, but again, I'm going to object because this is new information that should have been included in her initial declaration so that my client could have had an opportunity to respond. I saw that documentation that was filed this last week as being responsive to the pending contempt motion.
I don't see, Ms. Swindell, anything in your motion for temporary order or your declaration in support of a parenting plan that indicates that anybody has been grounded for 2 months for talking to you. I understand that you're alleging that there's parental alienation. So I understand that, and I don't know if that's
that's, yeah, partly due to the,
all right. Go ahead.
the alienation that I'm referring to is part of the lack of communication that he's been imposing on our children. If they communicate with me about anything that's going on in the house, he will remove their cell phones from them and tell them that they're inappropriate for contacting me about issues. And it's been going on now for 2 months with our oldest.
Again, I would object at this point due to the hearsay.
All right. So here's my concern. There's a couple of different things that I'm just going to put out here right now. So the parenting plan, the last court date was in mid to late March, where Judge Hahn entered an order appointing a guardian ad litem. She entered a temporary family law order, a child support worksheet, and a temporary parenting plan. Does everybody agree about that?
Yes.
And that temporary parenting plan was, I'm looking at it right now, has Judge Hahn's lining out a whole bunch of different areas, striking certain areas, reserving on certain areas, and clearly Judge Hahn made the determination on this temporary parenting plan. We can all agree on that, I believe. I understand that there is a motion. This is a little bit unusual for within 2 months to have a motion for a new parenting plan entered. There wasn't a motion for reconsideration of Judge Hahn's ruling. But if you're asking for a completely different parenting plan than the one that Judge Hahn just entered 2 months ago, I think it's most appropriate to be heard by Judge Hahn, since there's clearly a reason why she entered the parenting plan that she previously entered. And I will tell all the parties that I did not, and I know that there's a GAL on board now, so that could be additionally helpful, but I did not review anything prior to that temporary parenting plan being in place. So I don't have any background as to why that order was entered the way that it was ordered. So clearly, Ms. Swindell, you have some concerns with that. I can understand that and sympathize with that. I'm assuming you've been working with the GAL since they were appointed 2 months ago. Is that correct?
Yes, Your Honor.
Right. What I'm inclined to do, and I don't know if the parties are available on either July 2nd or July 9th, but I think this is most appropriately heard by Judge Hahn, since she literally just entered a temporary parenting plan in this case.
Your Honor, the contempt motion is scheduled to be heard on July 2.
Is everyone available on July 2nd?
Yes.
Yes, Your Honor.
All right. So I'm going to set this over 2 weeks to July 2nd, 2024 at 9:00 a.m. for Judge Hahn to hear the merits of the request for a new parenting plan.
Thank you.
So everything at this point will remain as is, and we'll come back in 2 weeks, and you can make your arguments before Judge Hahn.
All right. Thank you.
What matter is that?
Your Honor, if we may call Swindle and Sandana, I'm not sure if child support's being addressed today, so I just wanted to confirm if that's being done or not.
I'm sorry, what is the name?
Swindle and Sandana.
Okay.
On my docket, it's 15 and 16.
14? 24-3-00026-08.
Noel McLean appearing on behalf of the respondent, Tucker Sandana.
Do we have Ashley Swindell?
Yes, Your Honor, I'm here.
All right, thank you. Be just a second here. And I apologize, Miss Looney, you were indicating what now?
Well, Your Honor, when we were here last, Ms. McLean had indicated she'd been served with a proposed child support order and worksheets. And that at that time, I believe Judge Fassett was presiding and said that those were not available to the court. The state has not received copies of that either, and I don't know if the court has them at this point.
I had received a motion from Ms. Swindell, which is the motion for, I think it's number 13 on your docket. Ms. Swindell had filed a motion asking this court to modify the temporary orders by changing the parenting plan and the child support order. And we've objected to that, but
Do you know when that was filed?
I received it on May 23rd. It looks like it was filed on May 17th with the court.
Okay,
And so some of the difficulties that we're having is that Ms. Swindell will serve my office, have hand delivered to my office, or email us certain documents, but they tend to be different than what's filed with the court. So I had received I think it was a hand delivery, or no, it's an email delivery that included a proposed child support order. But I don't know I don't see where that's actually been filed with the court, just a proposed parenting plan, it looks like.
So when I went to go put them into the courts, they told me to contact child support. I have not been able to do that, and they didn't take those forms, and I had already scanned that all in and accidentally sent it to you as that.
all right, so the two things that I know are on, was the contempt and the mother's motion. So are you saying, Ms. McLean, bottom line is you don't have the same documents that have been filed? Is that what I'm understanding?
I have more documents so I do have a proposed child support order and worksheets from Ms. Swindell. She did not serve the state. And apparently the clerk's office did not accept those documents, but I have received them. I don't know if the court has proposed orders from her that include the child support order. She's asking to modify the parenting plan to change custody back to her, and she's asking to modify child support.
Okay.
And those are based on her motion that appears to have been filed on May 17th.
So what I have in regard to the parenting plan, but I do not see anything as to child support. And maybe I'm missing, sometimes it's hard to tell from all the documents and what is what, but I don't recall seeing any child support. And you're telling me, Ms. Swindell, that they didn't accept those documents, is that correct?
Yeah, that's correct. They referred me or they told me to go contact the child support people.
All right, so Ms. Looney, sounds like you have not been contacted yet.
We have not, Your Honor.
Okay. All right, so let's just start with that matter then. If the child support is not in here, the state has not been contacted, then it doesn't make any sense to proceed forward with that particular matter. Ms. Swindell, would you agree, since I don't have everything?
Yes, Your Honor.
Okay. All right.
And I would simply ask that the court reserve my client's request for attorney's fees, because technically this is the second time we've been here on this motion. We were in front of Judge Bassett on this motion on June 18th, which was set over to today's date. So I would just ask to reserve fees.
That would be reserved. Ms. Swindell, please reach out to Ms. Looney in regard to child support and get those served on their office of what you're proposing and your contact information. Ms. Looney, anything else that you need?
Your Honor, I can give her our physical address where she can drop off copies of her documents.
Okay.
Yes, please.
You can bring them to 1338 Commerce Avenue, Suite 305 in Longview.
Thank you.
All right. So let's go ahead and address the contempt matter.
Yes, Your Honor. So as I indicated, I do represent the respondent, Tucker Sundowna. We are asking the court to enter a finding of contempt against Ms. Swindell for violating the parenting plan as well as the restraining order. Your Honor entered the temporary parenting plan and restraining orders in this case on March 19th, so earlier this year. Our position is that Ms. Swindell has violated paragraph 4A1 related to the visitation. She's violated paragraph 4A 2D as in dog, related to not consuming illegal or legal substances without a prescription from her provider, and violating paragraph 4B1 for not obtaining a collateralized substance abuse evaluation. As can be seen from our sealed health documentation, Ms. Swindell tested positive for marijuana on May 3rd. Actually, she had submitted one on May 3rd of 2024. I'm sorry, she had submitted one subsequently to that. We waited 7 weeks from her last use. And so on a UA, her system should have been clean within 30 days. And yet the sample was nearly 5 times the cutoff limit. And not only that, she tampered with the testing because it shows that it was dilute. It is clear, even from her responses, that she's not stopped using marijuana. And now she's trying to suggest that she needs to be prescribed marijuana by going to a facility that's going to issue her a prescription just for the payment of a fee. The parenting plan provides, again, that she's not to use any substances, and we specifically waited to ensure that those would have cleared her system. But again, she continues to use in violation of the court order that prohibits that use. The parenting plan, as a result of that, has terminated her visitation and contact with the children. And I would also note that the restraining order also entered back in March, prohibited her from going to the school or coming within 500 feet of the children's school. The parenting plan also prohibits her from allowing the children to have contact with her significant Jason Musso. And so what you see from the original motion is that she went to the school, she dropped off a birthday gift for Jada. We provided proof of the gift and the cards that were delivered on May 17th. And then a second time, she sends her significant other, Jason, to the school to deliver documentation for the children. Simply inappropriate, in violation of the court orders and in violation of the fact that she's not supposed to be having any contact with these children. It is clear as well that she has not complied with the court's order to participate in a collateralized substance abuse evaluation. The assessment that she provides is a 1-page statement from Cowlitz Family Health Center. It does not include the information as far as any UAs that may have been collected at that time or what the results of those UAs are. It also is silent as to any collateral contact related to my client. And he tells you specifically in his declaration that he's not been contacted to provide collateral input for a substance abuse evaluation involving Ms. Swindell. And as far as we know, the guardian ad litem has not been contacted to provide that collateral information. There is no valid prescription for marijuana, and quite frankly, the suggestion that smoking marijuana is an approved method of administration for THC, there's no way to measure how much THC is being ingested. And obviously, marijuana was a concern with this court and Ms. Swindell's parenting, and she's simply attempting to try and legitimize her addiction. So we're asking that the court enter findings of contempt for willfully violating the provisions of the restraining order and the parenting plan. We're asking the court to order her to comply with the evaluation process. She should be required to do that within the next 30 days. We're asking the court to enter sanctions of $100 and attorney's fees of $1,500. And that in order to purge contempt, that she is to comply with all court orders. She's not to attend the children's school or contact the children directly or through third parties unless ordered by the court. Again, participate in that collateralized substance abuse evaluation within 30 days and to pay the judgments within 90 days from entry of the order with the court. And I have provided the court a proposed contempt hearing order.
Ms. Swindell?
Good morning, Your Honor. So sorry. I've been pretty open with my use of marijuana. I'm open with my doctors. I'm open with my therapist. Yes, I never went and got the medical marijuana card because there is a fee to it, and I just didn't feel like it's legal. So it's state legal. So I didn't feel like going and getting one until this happened, and then when he started using it against me, I went and was getting a legal marijuana card because he's known about my use of marijuana because him and I both smoked marijuana together when we were together. So my doctors are very aware of my use of marijuana. My therapists are aware. He was aware, and I just wanted. So I did fail that UA. I have been a daily marijuana smoker for over 5 years. It stores in your fat cells. So if you are just smoking marijuana a little bit, then yeah, it'll be out of your system in 30 days. If you are like smoke daily.
And I guess I would object as to her testifying as an expert. There's no qualifications that she has sufficient education or knowledge to be identifying how quickly marijuana metabolizes.
So the court understands that and understands what is acceptable and what isn't. We'll give it the weight that it deserves. Go ahead, Ms. Swindell.
I also want to bring up that Mr. Sindana had no problem with me smoking marijuana until I filed for full custody of our oldest son because he was having anxiety issues, and him and his father butt heads quite frequently. I've been trying to keep it very fair. I've been trying to avoid this entire time. I'm trying to do everything right. I do have the UA from the eval that I did that shows marijuana and nothing else. I passed a UA for my job that showed marijuana and nothing else. I did a hair follicle test that showed marijuana and nothing else. But yet Mr. Sindana, when beginning this case, had his attorney try to make it sound like I had substance issues that were bigger than just marijuana. And that's what led to this. He's been frequently exaggerating things, just like our last court that he tried to get a restraining order on my boyfriend, and his girlfriend tried to get one on me and on my boyfriend too. It was on November 7th of 2023. I have the number of it. It was thrown out because it was so exaggerated. They have been keeping me from seeing the kids. The moment the court issued the documents of the no contact order, He went to their school, he went to their doctors, he went to their therapist with a copy of it saying that I am not to be contacted for anything. And it clearly states in the parenting plan that I should be on there before any other, me and him only. And I still should have contact with schools, even though I cannot be at the school. I didn't go to the school. I had my boyfriend drop something off. He did not talk to the kids. He dropped it off in the office because his daughter goes to the school right next to it. He dropped it off in the office. He dropped off a birthday card from me and my uncle. That was it. Nobody talked to the kids. Nobody seen the kids. I did not go to their school, but they're exaggerating. Again, this is a habitual thing. He's using the legal system. He's using and this is just, it's getting to be so much that he's now trying to record us talking on the phone without my permission or the children's knowledge. It's getting crazy. And I understand that we have until we've been assigned a GAL and she's done her investigation, but it's not due for another couple weeks. But I really think that the court will see how much this is getting exaggerated and how much this is ridiculous. I can't afford an attorney. I'm trying to work and pay child support, raise a toddler myself. This is crazy. And I guess that's all I really have to say.
Ms. McLean?
Well, obviously, she acknowledges that she has continued to smoke marijuana in violation of the court order. She acknowledges that she sent Mr. Musso to the school in violation of the restraining order and in violation of the temporary parenting plan, which specifically states at paragraph 4A to E, the mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and or Kiana Musso or any known domestic abuser, drug user, or individual under the influence of alcohol or drugs.
Objection?
Her choice.
Can I say something?
What's your objection?
They didn't have any contact. There was no contact made. So I don't understand this.
Okay, you've had your turn.
Okay.
So let me hear from Ms. McLean.
So she sends the individual who she knows is not to have any contact with the children to the school to deliver items. And again, the restraining order prohibits her from coming within 500 feet of the school. There's absolutely no evidence before this court that my client has prohibited her from having contact by phone or email with providers. There's no evidence of that. It is accurate that the providers have been provided the restraining order to make sure that they're aware that she's not supposed to come within 500 feet of those facilities. And yet she's violated. So we're asking the court to grant the relief as requested.
I've reviewed the files and record, heard the argument here today, and the court does find that Ms. Swindell has intentionally, maliciously and intentionally violated the court order, restraining her from going to the school. Whether it's directly or indirectly, Ms. Swindell, that still meets the requirement of not having contact or going to the school. So if you send somebody with something to the school to give to a child, that's no different than if you're standing there and give it to the child. So also in contempt, as well as consuming marijuana and not obtaining the evaluation that was ordered, it is irrelevant as to the motion as to whether or not the respondent has smoked for purposes of this motion. You can purge a contempt by coming in compliance with the court order, including obtaining the ordered evaluation within 30 days and comply with the court order. You will be required to pay a $100 sanction and $1,000 in attorney's fees within 90 days of entry of this order. Ms. Swindell, you've been told no marijuana, no smoking, no having it, and yet you continue to do it. Whether you think that's okay or not, you're going to continue to follow through, or you're going to continue to have contempt motions brought, I'm sure. But it also weighs heavily on whether or not you're willing to follow a court order. And from what I can see, you are not. So with that, I will be signing off on the order.
So the court will need to make changes at paragraph 1 and 8 to reference the $1,000 in attorney's fees. And I will provide Ms. Swindell, Ms. Looney, and Ms. Evald with conformed copies of the orders once they're available on Odyssey.
I've made those changes. Ms. Swindell, are you okay to put approved via Zoom?
Yeah. Yes, Your Honor.
The only other thing that I would ask is if the court is willing to add in the language at paragraph 13 about reserving respondents' requests for attorney's fees relative to petitioner's motion to modify.
You can just bring that up if
Okay.
it's back again.
Okay, I'll just reference the clerk's notes then. Thank
Yeah.
you very much, Arnie.
Crossover.
Okay.
Ms. McLean,
Yes, Your Honor.
I have the one order that
I had also, that's the order that I had proposed, assuming the court denied Ms. Swindell's motion to modify the parenting plan.
okay. All right.
So you can round file that one.
All right. Thank you.
Thanks.
Next, I have Ashley Swindell and Tucker Sandana. And there we have Ms. McLean is representing Tucker Sandana, and Ms. McLean
Your
is
Honor.
present. I see her.
I
And
am.
then I see Ms. Swindell is on the line. Is it Swindell or Swindell?
It's Swindell.
Swindell, thank you. Both are present, and looks like we're, and then Ms. McLean, is your client, Mr. Sandana, on the line?
I saw him earlier.
Yes, I'm on the line.
Great,
Yes,
thank you for confirming that. Appreciate that. All right.
So it looks like Ms. Evald is also present, the guardian ad litem.
Great, thank you. So we have today's, it was docketed for the final GAL report, and when I checked yesterday, I didn't see that it had been admitted. Has it been filed, or is it still in process?
We've received it by email. I understood that Ms. Evald filed it. I can't remember which day, if it was last week or.
Oh, okay.
That is correct, Your Honor. That was filed last week at the courthouse.
Okay.
So I've received it.
Okay. Interesting. I think what happened, and I apologize for this. I knew my week was going to be full this week, so I started prepping over the weekend. But even then, it was filed on the 2nd. So, in full transparency, I didn't read it. I had noted in my notes here that no filing of the final GAL report.
And I just assumed, I didn't remember that that Judge Hahn wasn't going to be here today. She normally just uses these as place markers. And we would be following up with any motions if either of the parties desire to do so. So that was just sort of my anticipation.
Okay. Ms. Swindell, do you have any input?
I mean, I don't really know what's going on. I'm sorry.
Yeah, that's fine. So Ms. Evald has finished her report, and it's been submitted. And then generally from what Ms. McLean is indicating, that typically Judge Hahn will then await for parties to file some type of motion based on the information that's in the guardian ad litem report. So that's kind of that would be the next step. So today basically is kind of a marker. The report's been filed. Great. Thank you, Ms. Evald. And then if either party feels so inclined, then you could bring a motion asking for some type of relief from the court based on that information that's in the report.
Okay, so I need to file a motion then?
If you're so inclined, that would be the next step, right?
Okay, thank you.
Great. And then anything else, Ms. McLean?
No, thank you.
Okay, great. We'll conclude that, and we'll allow the parties to move forward as they see fit.
All right. So we have Ms. McLean. Do we have Sherry Evald? Yes. Do we have Ashley Swindell?
Yes, Your Honor.
Okay. All right, so let's go first to the guideline report. The report that I have was filed on August 2nd.
And I've received a copy of the report. I would note that I had also requested a copy of Ms. Evald's file. She has not provided the counseling records for the parties or the children, or the medical records for the children. I'm assuming that we need a court order for her to release those. Since I'm representing a party, I'd like to have access to those since it's a matter, I'm assuming it's going to have to move forward to trial, or first, I guess we need to do a settlement conference.
Ms. Swindell, any objections to that?
I don't think so, but I don't understand, sorry.
Want to restate your request, Ms. McLean?
That the court order that Ms. Evald is to release the copy of the children's and the parties' medical and counseling records that she reviewed for purposes of her investigation, and the report that she submitted to the court.
Oh, yeah.
Okay. All right. So with that, that request will be granted. Ms. Evald, you'll have to provide that information.
And I'll prepare a subsequent order to that effect so that she has that in her file to cover her.
Okay. All right. Anything else? I do not have a motion, which I typically will require before I adopt or make any changes based on a report.
And that was one of that would be one of my initial objections, is that there is no motion before the court. I would also object to the unsworn items that are identified as evidence that were filed by Ms. Swindell. Those are clerk's papers 82 and 87. And then I would also object to the basically the sealed personal health care, that's clerk's paper 88, because there's no
Hold on,
indication.
let's go through these one at a time.
Sure.
So looking at number 82, it looks like they are text messages.
Yes, but there's also boxes of basically what appears to be a declaration. If you look at the top of the first 2 pages.
I believe they're just explaining what's in the pictures.
Okay. So, Ms. Swindell, when you are filing anything that's a statement, it has to be a sworn statement. And if it's not, so I understand you're just explaining the pictures, but if it's not a sworn statement of what's being seen, then it can't be considered by the court. Okay, so.
Can you just look at the pictures and not, sorry, just like not read the top?
Well, I would agree with Ms. McLean. It appears to be a form of an affidavit or a declaration. So you're going to have to either comply with that requirement or it won't be considered. Okay.
Okay.
Ms. McLean, what was the next one?
Basically the same objection as to number 87, clerk's paper 87. That's again identified with the title page of evidence.
So this is similar, Ms. Swindell. Same idea. You'll need that sworn affidavit. Okay.
Yes, ma'am.
As it relates to clerk's paper 88, which is a sealed personal health care record, I have no idea who this is from. I don't know as far as what provider this came from. There's nothing that tells me, you know, the name of the facility or the address. So I'm concerned about that. That I don't have those types of identifiers.
What was this?
This is your sealed personal health care records.
Oh, for Jackson?
That's part of the problem, is it doesn't give the detail that would be necessary to identify who the provider is and who it's even having to do with.
Okay.
You know, but you can't tell from just looking at what's in the file. Okay.
Okay.
So again, the court will not be considering it until it has the correct personal identifiers. Ms. McLean?
The other issue that we've had is that consistently Ms. Swindell will either not serve my office or serve my office with items that don't correlate with ultimately what she files with the court. For example, I was served with a docket notice for August 20th, but she filed a docket notice for August 27th. We only found that because it was on Odyssey. And so my concern is that consistently I'm not being served with the correct or the same documentation and information that she's filing, or I'm not served at times at all. So I don't, this has been an ongoing issue. I guess the only other potential would be for the court to say that there has to be court approval before she files, with verification that she served me the actual stuff that's been filed. I don't know how to rectify that. But this is not the first time we've had this discussion. This has been an ongoing and consistent problem.
So the court's not going to order court review at this time. Ms. Swindell, you have to understand, anything you file with the court, Ms. McLean has a right to a copy of exactly what you file.
I am sorry that happened. What it was a typo, and I rectified it in the following email. What she's trying to get thrown out is the proof that I rectified it in the following email. So she's manipulating and lying.
So
I'll refile that to prove that she's manipulating and lying, but.
So you have to do that, or it won't be considered, bottom line.
Okay.
Okay.
Mm-hmm.
So these are legal questions that you can always consult with Cowlitz Wahkiakum Legal Aid. They come, I think, on Mondays, or Northwest Justice Project. Those are the two possibilities that are here locally. All right. So with that, this is in regard to the guardian ad litem report and the parenting plan. Again, I take a motion. I will not make changes without that motion, except in some exceptions to that. That report was filed. With that, anything further at this time?
I have submitted a proposed order to the court. We are asking for the court to award my client $750 in attorney's fees for having to be here. It's not proper. Technically, she did not provide correct notice, and then it wasn't timely notice, which meant that we had to engage in additional communications with all the parties involved and the clerk's office in order to set this matter over. So that I could have appropriate time for my client to respond. And of course, my client has responded, which again is time and effort, which means he's expended attorney's fees. I would submit that even if you look at the sufficiency of the information, there's been no showing of a substantial change in circumstances since the last time we were before the court in regards to contempt. So we're asking the court to adopt the order that I've presented to the court and award my client the fees.
Ms. Swindell?
The reason I filed this was because I assumed the court would read, the GAL report and understand what's happening here and do something about it. This is the second court hearing we've had for the GAL report. The first time it wasn't read. The second time, apparently, it does not matter. And this is sad. This is very sad.
But based on the files and record, I will grant the request and sign off on the order. Ms. Swindell, have you seen a copy of the order or not?
Yeah, I saw it.
All right, understanding that's the court's ruling, whether you agree with it or not. Are you okay if I put approved via Zoom?
Yep.
Right.
Yes, Your Honor.
We will provide a conformed copy of the order that the court has signed. And I guess my question for you is, would you be opposed to just interlineating at 6D that the guardian ad litem shall disclose? Or do you want me to go ahead and submit a subsequent order?
I would rather you go ahead and do a separate order and then just put not approved for Ashley Swindell's signature and then the date.
I just provide it ex parte.
As long as you put on there, send it to my attention and
Okay.
just put that, as she said, she's not approving it. So just put not approved and the date. 326-08 Swindell v. Sindana.
And Noel McLean appearing on behalf of the respondent Tucker Sindana, and I believe that Tucker is also present.
Okay. Right. And we have Ms. Swindell. Be just a second here.
Your Honor, Sherry Ewald, guardian ad litem.
Thank you. All right. With that, I believe this is on for a request to adopt the recommendations of the guardian ad litem. If you want to go ahead.
Me, Your Honor?
Yes.
Okay.
It's your request.
First, I wanted to apologize for how I've been mishandling my paperwork. I am currently trying to learn how to navigate the legal system, and I've spent countless hours in the courtroom with my 2-year-old trying to make sure things are filed properly. I would also like to talk about the TikTok videos that Mr. Sindana has referenced. The videos he cites with the Nicki Minaj song, which include the lyrics, "I just fell in love with a gangster," is simply a part of a popular trend, and gesturing of the flipping of the bird in the video was not directed at anyone in particular. It is important to note that Ms. Gopal herself has posted similar photos of her flipping the bird with captions like, "I guess I win again," after court. I have multiple photos and videos of me doing this directed at nobody specifically. The second video, I also used a viral sound that thousands of people have used, and I titled it, "When Your Ex Finally Pushed Your 6'4" fully reformed ex-convict to his limit." It was to try to make light of an incident that had already happened in the past where Mr. Sindana, when I showed up to Mr. Sindana's house to drop off things for my kids, at Mr. Sindana's home, a visit that he was well aware of. When I arrived, he refused to let the children come out to meet me, which forced me to approach his home. When he answered the door, he was visibly armed and told me that I could not speak to the children while having confiscated their
I'm going
phone.
to object at this point, as this exceeds the scope of the declarations.
So, Ms. Swindell, you can only argue what's in the documents that you have filed.
This is the very first page of my document.
Yeah. Ms. McLean, do we have a child present?
I'm sorry, yeah, my 2-year-old. I am waiting for my fiance to get home from lunch break to help me. She's just playing in the other room.
Okay. As long as it's in your declaration, go ahead.
Um, yeah, when I was there, I expressed my concerns then at the time for parental alienation, as he has taken my children's phone and would not let me speak to them and would not let them come outside to get the stuff that they had requested. Mr. Sandana has exaggerated this situation, falsely claiming that my partner, Mr. Musso, showed up to threaten them and him and his girlfriend, Ms. Goebel. We went to court for that because he tried to file a restraining order, which was dropped. And Mr. Sandana has continuously claimed that my partner, Mr. Musso, is a white supremacist based solely on his appearance. Mr. Musso, while physically imposing, is not and has never been affiliated with any STGs. It is important to note that when he went to court to try to file a restraining order, he was not trying to change the parenting plan at any time. It was not until I filed to change the parenting plan because my oldest, my 15-year-old son, asked to live with me full time because him and his father had been arguing. After my children and Mr. Sandana moved in with Miss Goebel, she quickly became involved in our children's lives, including coaching our daughter's soccer team. While I appreciated her involvement, I was hurt by how clingy she became with our children, particularly our youngest, Jada. Despite my best efforts to build a cordial friendship with Miss Goebel, reaching out to express my appreciation, she often responded dismissively, rudely, or not at all. Though Miss Goebel has portrayed herself as a mediator in the situation, she has been far from impartial. She has made hurtful comments to my partner, such as she has a better relationship with my daughter, Jada, than I do. She has exaggerated incidents, including a remark I made about her appearance in a private text message to Mr. Sandana, and has said that I loudly proclaimed it in a soccer game, which was extremely untrue. I want to address the statements made by my father, Matthew Swindell. I've never accused my father of inappropriate actions towards me. However, I have accused him of inappropriate behavior towards my cousins, including one of which who lived in his home from the age of 7 years old. Additionally, the home I built next to my father's property was not a choice, but rather a condition imposed by my uncle Scott Swindell, who controlled my mother's trust, controlled the trust left to me by my mother. He restricted my ability to purchase any other property, forcing me to build next to my father, the property that him and my father both owned. The truth is, I never had a meaningful relationship with my father or his family during the time I lived there. I did ask to move in with my father in 2012, but this was only after Mr. Sandana's mother physically assaulted me in front of our 3 children. We were living in her house. It was a very rundown house, and we were all 5 of us living in one bedroom. Mr. Sandana was not working at this time. After a month of living with my dad, I was able to get a job and a home for me and my family. I have very vivid memories of my father verbally assaulting and degrading me from ages 11 to 17, but I have never said I have memories of him touching me inappropriately. However, I lived in his home when one of the inappropriate actions towards my cousin occurred, which eventually led to her running away as a senior in high school. Throughout this case, I have been open about my mental health struggles, and I have actively been working with my therapist, prescriber to manage my PTSD, depression, and anxiety. While I have had one attempt in my past, Mr. Sandana consistently exaggerates this, falsely claiming that I have had multiple attempts. He also manipulates my marijuana use, even accusing me of using hard drugs earlier in this case. Contrary to what Mr. Sandana claims, I have never expressed a desire to smoke marijuana with my children. His accusations are baseless, and I believe it is fabricated to further his smear campaign. My primary concern has always been the well-being of my children. I have attempted to raise important issues with their doctors. Despite this, Mr. Sandana failed to refill Jackson's medication after March 19th, 2024, when he was placed in his care. Without consulting his doctor, while stopping the medication may ultimately have been Jackson's choice, the sudden discontinuation could have serious side effects, and I believe that these decisions should be made with medical guidance. Your Honor, my concern in this case has always been my children's mental health and well-being. I feel the smear campaign orchestrated by Mr. Sandana, Ms. Goebel, my father, and Kristen Otto is designed to discredit me as a mother. While I am not perfect, I have been doing everything in my power to heal from a lifetime of abuse and trauma. I'm working closely with my healthcare providers to manage my mental health, and I will continue to fight for what is in my children's best interest. The GAL report reflects the best interest of my children, as it should. However, it is clear that anybody that doesn't side with Mr. Sandana becomes a target for his attacks, further demonstrating the manipulative tactics. Despite everything, I will never stop fighting for my children, and I trust the court will see the truth behind these accusations. I also want to bring up the fact that our court hearings have been all recorded and posted on YouTube, and then a TikTok account was made in August to also post all of those. They have reached over 120,000 views. I talked to the court. I went to the court the day I found out, and I asked them if these were posted on YouTube, if anybody has any way to access them. They said no, that the only way anybody could access them was if they were logging into our Zoom courts and recording them. I feel like this is part of another part of his smear campaign, that he's orchestrated other people to come into our court hearings and record them and then post them to further his agenda. I'm hoping that the court takes what the GAL has to say seriously. It makes several claims that Mr. Sandana is very controlling, that his children have claimed that he is very controlling and make him feel uncomfortable, that he stands very closely to them to monitor any conversations that I have with the children. I believe that this is very unhealthy for my children, and it needs to be addressed.
Thank you. Ms. McLean?
Thank you very much, Your Honor. So first off, obviously, I am concerned about the declarations submitted by Ms. Swindell that don't comply with the local court rules, and the additional declarations that are beyond the page limits and the pagination of that. So I'll just point that out to the court and leave that to the court's determination as to what you consider as it relates to those issues. And as you commented earlier on this docket, the guardian ad litem report is simply that. It's a report, and it's totally up to the court to ferret out the evidence and make a determination on what the court believes is in the children's best interests. In regards to the facts that are outlined in the guardian ad litem report, we've submitted my client's reply declaration as well as 2 witness reply declarations outlining the irregularities and the concerns as it relates to the inaccurate information or factors that were submitted as part of the guardian ad litem's report. And again, ultimately, it is the court that is to consider the facts and the information, weigh the credibility of the parties, and ultimately make the determination on what you believe is in the children's best interests. I would submit that given the substantial differences in the information that we've provided in the declarations, that this is something that a trial court needs to hear. I believe that I've noted it up for mandatory settlement conference assignment. We haven't had a mandatory settlement conference yet, so we'll participate in that process. And if we're unable to reach an agreement, then ultimately it's a matter that needs to go to trial. I would note that first off, there has been absolutely no substantial change in circumstances in the factual scenario of this case since the temporary orders were entered. And Ms. Swindell has now been removed from that joint custody that they were previously exercising since early this year. And because of her own behaviors, totally within her control, her own behaviors have resulted in her not having any contact with the children since May of this year. So she's been 5 months without contact with the children. And the court has ordered her in 2 separate orders. One, your contempt order that was entered on July 2nd, and as well as the order that you entered on September 17th. Both of those orders required Ms. Swindell to participate in a new collateralized substance abuse evaluation within 30 days. We are 3 months removed since the July contempt order was entered, and she has provided absolutely no proof of any efforts to stop smoking marijuana, no proof that she has a clean hair follicle in UA, no proof of a collateralized evaluation. So right out of the get-go, we have absolutely no verifiable information. One, that her prescribing physician has, or psychiatrist, has approved her use of marijuana to treat her PTSD, depression, and anxiety, as she suggests. Those are significant concerns, particularly in light of her past behavior as a result of her depression with a attempt with the children in the vicinity. It's also concerning when you take a look at her reactive nature during the pendency of this case. She certainly cannot control her reactions to benign emails of information that are provided to her. She has to react and engage in conflict. And as the court knows, there's multiple studies about how dangerous conflict is to children. She attempts to switch it up and suggest that Mr. Sandana is the one, he and his girlfriend are the ones that are engaged in conflict, but you have no documentary evidence or factual evidence to support those baseless claims. So at this juncture, you have a mother who, again, holds all of the answers to her concerns, and that is she needs to get clean. She needs to do those evaluations that the court ordered and follow through with her mental health. And she herself identified that her mental health is a concern and that she's done all of these things, and yet we have no verification that she is stable. In addition, it's concerning that her marijuana use is somewhat normalized in the guardian ad litem report and recommendations. The recommendation from the guardian ad litem was, well, maybe she needs to do a substance abuse evaluation. The court's already ordered that and she's not complied. We have concerns that as it relates to her own documentation that we filed from her mental health provider, where Ms. Swindell identified that she was an habitual user and she was engaging in excessive cannabis use, and that was also adopted by her counselor. That was one of the findings. That's from November of 2023. The Columbia Wellness Record acknowledges that there was an increased risk due to alcohol and substance abuse. Couple that with the CPS records, where the oldest child is reporting to CPS that he's aware of mom using, he's observed mom using, he's observed her using a vape pen and a bong. And again, we're talking about an impressionable child who was 14 at the time, now 15. Couple that again with the fact that one, we are here because of her behaviors, and her immediate concern was addressing those TikTok videos. She, the TikTok videos, as well as the court hearings that have been streamed. We have absolutely no control, and I don't know what control the court has over somebody recording those videos. We're aware that we're not allowed to do that. My client tells you he has not done that. My client has provided you documentation where he has reached out to the one of the posters, one of the individuals who post, or the identifier who posts those videos, and there's been absolutely no response. My client, his girlfriend, Ms. Swindell's father, have not video recorded those. And you'll even see in my client's, I think it's Exhibit C, is this is attached to his declaration that we filed on September 17th. Oh, I'm sorry, not that one. We filed it on September 26th, where Ms. Swindell engages in communications about at least her perspective of this, and you can see where there's multiple other hearings from different jurisdictions that are populated under these sites. But simply to point out that my client has not done that.
Yeah,
My
I
client,
understand.
too, is concerned about the children seeing that. And go back to Ms. Swindell's TikTok videos that she herself has posted, and she has hashtag divorce and hashtag co-parenting struggles. Those are things that her children can see, and she's the one posting those, and yet she's complaining about these hearings being potentially available to the children. The children can search her name and see her TikTok videos. Extremely unhealthy, particularly following these hearings. My client tells you, and his significant other tells you about the concerns where, first off, Ms. Goebel was asked to be essentially a mediator between the parents, the suggestion by the GAL about her being the mediator, and yet her advising Ms. Ewald about the significant other of Ms. Swindell, Mr. Musso, one, his felony history involving very dangerous assaultive convictions, and two, the ongoing threats of him essentially being the heavy to enforce Ms. Swindell's wishes. That type of optic is not good, particularly when you have an individual such as Ms. Swindell who's invested in drama and conflict. The declarations outline significant concerns about the disruptions during some of the interviews, the nature of some of the conversations. Even Ms. Swindell in her argument says, you know, I've never made allegations against my father. Look at the guardian ad litem report. The guardian ad litem report in and of itself acknowledges that the father, the grandfather, maternal grandfather, should not be present because of the, and this is number 12 on page 24, due to mom's statements regarding her childhood abuse by maternal grandfather. Maternal grandfather should not attend any event or function. That's the guardian ad litem's conclusion based on Ms. Swindell's own statements to her that she was abused as a child. She says something completely different today. So
Objection. I believe I said I was not abused by my husband or by my father.
Okay. All right, wrap it up, Ms. McLean.
okay. So our position is that the court should not adopt the recommendations. Ms. Swindell has not complied with the court orders. She's continuing to use. We have concerns that she continues to not be mentally healthy, and we believe that the court should deny the request, adopt my proposed order that I've submitted to the court, and award my client $1,500 in attorney's fees for having to respond to all of this.
Ewald, anything you wanted to add?
Yes, Your Honor, thank you. You know, I understand parties not loving the report all the time, but I did have the opportunity, a unique opportunity that I've been able to speak to all parties, including the references and the collateral. I've been able to see the substance abuse evaluation that was done. I've reviewed medical records. I stand by my report. I'm very comfortable with it. These children are older, and my job was to be their voice, and their voice is that they would want to be with their mom and dad. Both mom and dad are good parents. I didn't say they weren't, and I firmly believe that that needs to take place. I did review my recommendations. I don't see anywhere where it stated that I felt mom needed to have another substance abuse evaluation. Noelle, Ms. McLean had brought that up. I don't see it in the recommendations. I didn't review the full report right now, but I do stand by this report. I'm very comfortable with my findings.
Thank you. Ms. Swindell, keep it short. I still have other cases. You have a chance at rebuttal.
Yes, ma'am. Thank you. I would like to say that I did do a substance eval. It was April 23rd, 2024. I had given Miss Noelle the copy of the substance abuse evaluation that said no treatment is recommended at this time and that I have no substance. Mr. Sindana did not reach out. They claimed that I gave them the wrong number, which I followed up and corrected my typo. They're trying to say now that I did not give them the right number, but I did. And he has called the substance abuse lady, Michelle Buckles. He's called and given her collateral information that did not change anything, and he's unhappy with that situation. So he wants me to complete a whole nother one. I don't think that that's fair. I think that he is, anytime anyone doesn't side with him, he's going to want something new. And I think that this is an abuse of power, and abuse of money, quite frankly. And I just hope that you see what's in the best interest of my children. I'm, like the GAL said, we're not bad parents. We have conflict between us. And I'm hoping that that conflict can be resolved and we can move on with our lives. This is absolutely out of hand.
So I did review the files and record, the statements that have been filed. And the court recognizes the guardian ad litem spent a lot of time investigating this matter and appreciates the work. And again, as I say, guardian ad litem reports are a recommendation. Clearly, there are disputes as to what's been said, which is not necessarily unusual either. Clearly, the parties see things differently, and there's only one way to get this matter resolved. And so the court is not going to be changing anything at this time. And the matter needs to get noted for trial. I think you said there's an MSC.
I believe that I noted it up for an MSC. I apologize. I should have looked at that date.
When is it?
Um,
November 18th.
yes.
Okay. So Ms. Swindell, do you know what MSC is?
Kind of.
Okay. So it's called MSC for Mandatory Settlement Conference. And it's an opportunity to meet with the judge. That judge then recuses himself after hearing in the MSC. But basically, the attempt is to see whether or not the parties can reach an agreement rather than proceed to trial. So that's the idea of an MSC, is to see if a settlement can be reached between the parties.
And there is more information available on the court's website that she can access, and we can forward that link to her if she needs it.
Okay. So why don't you go ahead and just do that, Ms. McLean, if you would. And so that will be happening. But bottom line, the matter needs to get set for trial. It needs to be heard as a whole as to what needs to occur. As to the request for attorney's fees, the court understands why that request may be made, but I think Ms. Swindell properly brought the matter before the court. And the court doesn't find any fault in that, just not agreeing at this time to make changes. So
Do
that
you
request is denied.
Do you want to do a presentation, or do you want to make adjustments to the order that I did provide to you, or?
So what I would suggest is just get me a clean order.
Okay.
And if you can't come up with a signature by both parties, then note it on.
Okay, I can do that. Thank you.
Yeah. All right, number 11, you say?
I do believe it's number 11, the Swindell and Sindona matter.
24-3-2608.
And I just, sorry,
ahead.
Judge. I just entered my notice of appearance yesterday. I've been in correspondence with Ms. McLean, and I believe we have an agreed order coming over ex parte. So my understanding is we can strike today.
Or if you have the document in front of you, perhaps you could just acknowledge that Ms. Bliss approves by Zoom.
And that's fine with me as well.
I'll have to, hold on here, let me get the folder. Okay, so I do have the order that was sent over by Ms. McLean, and that's the order that you are approving, Ms. Bliss?
Assuming that's the order I saw yesterday, I'll defer to Ms. McLean, but I did sign off on the order that she presented me yesterday.
Yeah, it should be the 2-page order that both I and Ms. Ewald had signed.
That's what I have.
Okay, then yes, Judge, you can enter my approval via Zoom.
Thank you.
Thank you, Judge.
Ashley seems pretty happy with what's in the GAL report, which is why I think she was trying to get the judge to adopt it right then. But it's not unusual for the judge to leave things alone and let them try to figure it out at their mandatory settlement conference. And speaking of the mandatory settlement conference, it's scheduled for November 18th, which isn't that long from now anyway. I'm glad that Ashley will have a decent lawyer going into the settlement conference. She needs someone who can stand up for her against Attorney McLean. The amount of custody time she's awarded should be based on the evidence and not fancy legal moves or a lack of understanding on how to file documents. Miss Bliss will make that fair for her, and that will all come down to the best interest of the children. I hope they can work this out in mediation for the children's sake. This will be the final update in this case, as this courtroom has returned to in-person hearings. These two may not have returned to the docket after their mandatory settlement conference anyway.